division bench judgment of this court. मैं alia also एक ही है मतलब मैं
Item number 38.
38 है. I talked to the other side मतलब can it be taken up at 2 p.m. covered by 2 division bench judgment.
The defection disqualification.
Yes,
is the-
they do not. The council doesn't have the power to make such law.
What do you want actually?
Well, it may be taken up at 2 p.m. This the rule which has been made by council, it has to be quashed.
We will hear and see what is the matter.
Yes, your
covered.
lordship will hear at 2 p.m. because I mean,
Yes.
Adjournment request, if any, from item number 1 to 6.
May please, your lordship. I beg to mention item number 3, my lord. I have already circulated it here. Already.
This matter may be wrongly listed in order column, my lord. Sorry,
Item number 3.
Yes, please.
Orders or admission,
Yes.
we don't care for it. Now, whether it is listed, a prayer for
Immediately-
adjournment has been made
immediately after revocation.
as an adjournment slip has been circulated on behalf of the appellant with the consent of the other side for adjournment of this case. The case is mature and listed under the heading admission. Let this case be listed for admission on your date anytime in May. Yes,
7 May.
May I please to your lordship, I beg to mention item number 6. We have submitted adjournment request.
All right. yes, give the date.
11 May.
Obliged.
From item number 7 to 14, adjournment request. From item number 15 to 31.
Lordship, I may be allowed to item number 16, my lord. 16, with liberty to file a fresh, my lord. Here are some particular error, my lord.
What's your name?
MH Saikia, my lord. MH Saikia,
Mr. Emmett Saikia.
MH Saikia, my lord.
Mr. Emmett Saikia and an advocate for the applicant seeks permission to withdraw the aforementioned interlocutory application number 840 of 2026 with the liberty to file a fresh application declaring for the same relief. For the same relief. Dismissed as withdrawn with the liberty of consent.
May it please the lordship.
Yes.
Lordship, with the consent of the petitioner, I beg to mention item number 28, lordship.
As break for on behalf of the respondent. Having obtained the consent of the council for the petition, the matter is adjourned to your date in May.
11 May.
Highly obliged. May it please the lordship. This should be the consent of the other side. I beg to mention item number 29, lord.
Coach 9, all right, adjourned. As break for on behalf of the break for on behalf of the appellant. It's an appeal and agreed to by the council for the respondent. The matter is adjourned.
18 May.
That's good.
Yeah, please, Lordship. By taking consent from the other side, I beg to mention item number 22, Lordship. Lordship, we have circulated the adjournment slip yesterday,
18 May.
18 May. Obliged.
From item number 32 to 39.
May it please your Lordship. This is with regard to item number 32. I'm
All right,
appealing.
you have circulated here.
May it please your lordship, lordships with the concern of the other side.
Give the date.
12 May.
Yes.
Lordship, may it please your lordship, lordships with the concern of the other side, I beg to mention item number 23 of today's daily list.
Yes.
Lordship, as per the last order that your lordships had dictated, there was some specific instructions that we needed to obtain regarding as to whether the measures which were implemented. Lordship, that instruction.
Anti-quakery.
Yes, lordship.
But the law is in place, the notification has come.
Lordship.
Perhaps the petitioner wanted some suggestions to be
Yes,
incorporated.
Lordship, that particular instruction.
As prayed for on behalf of you are for the respondent, as
Yes.
prayed for on behalf of the respondent, let this public interest litigation be listed.
In June.
Much obliged. Lord.
May it please your lordship. Your lordship, I'm appearing on, I beg to mention item number 26. I'm appearing on behalf of the petitioner. Your lordship, due to certain unavoidable circumstances, my senior is not able to appear before this honorable court.
As prayed for on behalf of the petitioner on account of unavailability of the who's to address this court. And after the consent from the council for the respondent, let the matter be adjourned.
28 May.
Deeply obliged, your lordship.
Any other request?
My lord, I'd like to trouble this court, my lord, for listing of an IA, my lord. Tomorrow, the reason being the urgency being, my lord, that the writ appeal is pending before this honorable court. And your lordship had not interfered with the order of the learned single judge. The matter pertains to transfer. And your lordship had categorically stated that the state respondents are supposed to direct it to accommodate the appellant and the respondent.
No, we didn't say that. We remember very clearly.
1812, my lord.
This was somebody from
Dibrugarh,
Gauhati.
my lord.
We remember very vividly. We said that if possible.
My
If
lord,
possible.
on 13th, when the matter was last listed, my lord, there was an assurance by the state that the appellant and the respondent will be accommodated
No,
on the same day, my lord.
no, probably you did not hear the
No, no.
Advocate General was asked to
My lord.
look into the matter. He said that both of them are required to be transferred to different places, no accommodation, because many things have been seen. Now, if you want the affirmation of the government order, we can do it tomorrow.
That is what has happened, my lord. I was not there on that day. When, on the same day, my lord, the transfer
Therefore,
was
we are
effective.
reminding you, we
My lord.
remember quite vividly.
My
These
lord.
are judicial officers who have been transferred
True,
from
my lord, true. Presiding officers, my lord.
the industrial tribunal and we remember.
My lord.
We wanted it to be done in such a way that both of you are accommodated,
My lord.
but it does not appear to be possible. And we'll go by the government, the administrative decision to transfer.
My lord.
We will not, I mean, this is telling you beforehand.
My lord, my-
This is in accord with the law that governs the law of transfer.
True, my lord. It's an incident. My lord, if we may be. permitted-
Anyway, you want it tomorrow, we will have it tomorrow.
Tomorrow,
If you
my
want
lord.
it Some other day, we will have it at some other day, but
I understand, my lord.
This
I
is the
understand.
view of the bench.
Since my senior will be appearing, my lord, tomorrow, if I may pray for a date tomorrow, my lord, or tomorrow, the matter. If,
Then don't
if it's-
mention it. Fix a date, have a date in your mind, then make a mention, we'll have it listed.
tomorrow, my lord. Tomorrow.
You want it tomorrow?
Tomorrow, my lord.
List it
because-
tomorrow.
Yes, my lord.
All right, tomorrow.
I'm grateful, my lord. That was what was. I'm grateful.
All right.
Daily list for orders item 1 and 2.
Lordship, in this case, I really lordship, cut a fine. Your lordship, due to some confusion, state procedural. On 31/2026 directed me to take steps through a publication in newspaper law.
By which order did you?
31/2026. Earlier to the steps on respondent number 1, but it didn't appear. That will be prayed for publishing in newspaper law.
But then you have not taken steps.
Lordship,
Why?
Lordship, due to some confusion, could not be taken.
What confusion? This is an
Because
appeal
Lordship,
of-
yes, Lordship, order is clear, Lordship, due to our mistake. Lordship.
If you take that mistake on yourself, you will be forced to do it. But then I don't think the appellant is interested. The state is interested.
Lordship, respondent 2 and 3 appeared, Lordship, but one is he voting for service.
Two more weeks. Who appears? Are you sure?
Yes,
Number one
for
is not
2 and
appearing?
Yes, he is not. A
Again. Mr. Kayal, learned advocate for the appellant seeks 2 more weeks. Seeks and 2 more weeks to comply with the order dated 31/2026 for taking steps for issuance of substituted notice on respondent number 1. The steps must be taken within 2 weeks. Failing which, the appeal shall be dismissed without further reference to the bench.
What?
The rule is made returnable on the dates and times in June.
Much of
10 June. Item number 4.
My lord, pursuant to your lordship, order dated,
Response of the served.
Dusty mode we have served, my lord, and page
You have filed
40,
the affidavit that you have served.
there is two affidavit, my lord. The other affidavit is demanding compliance from respondent one.
So, can you tell us that you have done your part?
Yes,
Here, it appears that all the respondents have been served. Some of them have been served justly as well. Let this matter come up for admission on so and so day.
my lord, I have a prayer, my lord. There is a connected IA, my lord. And your lordship may pass their order for substitution, my lord.
Let it come on that day.
It is already in record, my lord.
Let it come on that day.
18 May. Item 5.
Yes,
Here also we start the notice by way of Dusty. Case 92, Dusty has accepted the notice.
awaiting the appearance of the respondent of this matter. The case is adjourned to your date ends in.
29 April. Item 7.
Yes, for respond number 1.
I have a few more.
All right. Would you like to respond?
All the materials are on record.
Mr. Indrajit Chaudhary, learned senior advocate, as appeared on behalf of respondent number 1. With this, they notice, with this, you are the sole responder.
Yes. AG is there, they're with you. Accountant
Just, Mr. Indrajit Chaudhary, learned senior advocate, has appeared for the sole respondent. Let this matter come up for consideration under the appropriate heading of admission on the matter.
But may I pray, this is the very sad state of affairs.
Now, what do you want?
An early date, no?
After the
28 April. 28. Item 8.
Yes.
My lord, this review petition against the order passed by the Honorable Court dated 11th of February 2026. The fact of the case is this, Lord says, along with the writ appeal, I have filed a condonation petition, IA, Lord. When the IA was called for hearing, Lord, my learned friend submitted that the writ appeal has been filed after passing of the order by the appellate authority, which is absolutely incorrect, Lordship. Because, my lord, I have filed the writ appeal, Lordship. I have filed the Lordship, the writ appeal on 11th, 12/25, Lordship.
Prior to filing of the appeal, no?
Prior filing, before passing of the order by the appellate authority. Appellate authority order is dated 31st, 12/25.
That's all right. But then after the final assessment, did you file an appeal before the authority or not? You did.
No,
Under 127 of the Electricity Act.
now,
you did file.
we had filed a writ petition. And in that writ petition has been
That was
noticed.
an appeal before the appellate authority, sir.
No, Lordship, my writ petition was allowed by the
Anyway, we don't find the reasons to be good enough.
Lordship, the mere on the submission of the learned counsel for the APDCL or
No,
respondent.
that is not the ground on which the order has been structured. That's one of the grounds that may have been stated wrongly. But then the fact remains that after the final
Lordship,
assessment.
in the writ petition, we have challenged that the appellate authority has no power of review.
Therefore, what is
And-
the ground that challenge that order?
I may be heard, my lordship. There is,
What are we doing now if we are not hearing you?
Lordship, there is no provision for review in the Electricity Act, Lordship, under the section 127, Lordship. When there is no power, so when the appellate authority exercise the power of review, Lordship, always the review is the creation of the statute. If there is no provision for the review in the statute, that power cannot be exercised. So that's why I file against that order passed by the appellate, I file a writ petition, and which has been admitted, and the stay has been also granted.
In any case, you succeeded there because the appellate authority.
No, Lordship, we please to consider, when the DPLP was allowed in our favor, Lordship, the learned single judge, the last para observed that the APDCL, that is the respondent, may file a review. So that's why when there is no provision for review, that's why we file a writ appeal. And writ appeal was filed on 11th of December 25. And in the second writ petition, we have challenged the.
Tell us one thing. Now, notwithstanding the absence of any specific provision for review, on the asking of this court, or on the asking of a learned single judge, you preferred a review that was entertained. And the appellate authority, the reviewing authority directed the PCA to undertake a fresh assessment. So you succeeded there. Now you say that no, there was no power to do that.
The press writ petition is entirely a different thing. There we have challenged the impugned order of the appellate authority, Lordship. And in the present case here, Lordship, in the writ appeal, I have challenged.
Dismissed.
Item 9. The office note indicates that the service report awaits in respect of
What
respondent.
is that one?
Service is better.
Awaiting the report regarding service of notice on the respondents, response number 1 and 2, the battery captured name.
20th May 20. Item 10.
Make judicial option, my lord. My lord, the order slash is page 13, my lord. And the relevant portion of the order is at page 19, lordship. My lord, second para of the order. The school authority and learned council for the respondent appearing for the managing committee, the Howrah Court along has made a statement before this court that the management of the school concerned has principally decided to relocate the upper section of the school in question to a new plot. My lord, now the direction is at page, my lord,
Just a minute.
my lord,
With the expectation, read the order.
my lord, yes, my lord. Page 20, my lord. In view of the fact that the managing committee of Sankoda Vidya Niketan, however, Tribunal has principally decided to relocate the upper section after 8 or above referred school, we dispose of this PIL with the expectation that the managing committee of Sankoda Vidya Niketan, however, Tribunal will initiate the process for relocating the upper section class 8, the school in question, within a period of 1 year, madam.
That was the pious wish of the court.
Yes,
There is no direction. They are not, let them do that. If they
Yes,
don't do, come.
madam, they
with
have,
fresh
because
application.
Because within 1 year we have to come, my lord. Order is at the 24th, my lord. Now, my lord, they have not taken any steps.
Within a period
Because-
of 1 year. This order
yes.
passed when.
24th, my lord. 2025.
So
My lord, until and unless a notice goes,
before
they
1
will.
year, before 24th, 2025,
25.
and you have come before 24th.
Because within 1 year you don't. My lord, kindly see, my lord.
They don't even issue notice.
My lord, because,
Take an adjournment in the meantime, by 24th, they may
My-
take up some steps
my lord, no.
as great.
Let it come after Bihu, my lord.
as
Oblige.
This is not a case for contempt.
But, my lord, lordship,
You have not
this
annexed
school
that
is causing
order.
serious problem to public.
You have not annexed that order dated 13/9/2022. For which you have filed this. Yes, so you 13 to pound. So you have to see it.
I will file one additional.
No,
I
we might modify the order.
My lord,
So really, we might even modify the order because this is the bench of the same strength. We'll modify the order.
Let me file the additional effort after Bihu, my lord.
Better option for you is to withdraw, file a fresh writ petition.
My lord, limitation will be there, my lord. Let it be after.
Litigation, so contempt, how do we enter into contempt jurisdiction if we don't find any positive order having been breached? Withdraw this or we modify the order on our
After Bihu, my lord,
self-assessment.
after Bihu, I will satisfy.
Yes.
By way of filing additional.
Straightforward, yeah, we please let this matter come up for consideration.
My lord, obliged.
11 May.
But
Item 11.
order 29/7/2000 today, page minor 37, operative page portion page 43, minor.
Which matter has been called out? 11. Yes.
Operative portion page 43, minor.
Let us see the order first.
Order
Page.
page 43, operative portion.
What is the earlier judgment?
Earlier judgment, minor.
That is important because it is.
Yes, yes. Earlier judgment I annex, minor.
Just,
Page 15, minor.
just a minute. Similarly situated ground, huh?
That's why I'm asking.
Earlier judgment, page 21, operative portion.
Can now work out the benefits of which petitions are entitled. Let's notice the issue. 2. The answering respondent. This application has been filed for initiating contempt proceeding against against the respondents for not having complied with the directions contained in the judgment dated 29/7/2025 of according the benefits to the petitioners, which has already been granted by the respondent to other casual laborers of the same ilk. Let notice the issue to so and so on steps being taken by the petitioner within a period of 2 weeks.
No.
A period of 3 weeks, both modes returnable June. Thank you.
Item 12.
May I please, your lordship?
There should be any objection in impediment. The application of impediment is allowed. So and so is added as a response number. So fresh memo of parties shall be filed by the applicant in the registry within a period of 2 weeks for the application stands allowed. Take it from. That's what we said. No, file a fresh memo of parties.
No, here I'm responding for, as a respondent, section.
Mushkil understand, but you will have to change the memo of application. New respondents is to be.
Yes, yes. Yes, my lord.
Mr. Parwa, if you don't want to do it, if you don't want to file 2 pages.
No, my lord.
We will ask. You to do it.
No, my lord.
You raise an objection on this.
My lord, am I not understanding your question? I'll definitely do it.
Scott.
No, definitely I'll do it. My lord, highly obliged, my lord, I'll do it.
You're asking.
No, because I could not hear actually what on the.
We'll give. Did it decide that you should.
Yes,
treat
my
it and you will take it?
sorry, William, sorry.
All right.
6 May. 6 May. Item 13.
For implement of the applicant as the.
Think you would object to it.
Lordship.
File your response. We get Mr. So-and-so appearing for. You are for? You appear for?
Opposite party number 1, your lordship.
Mr. So-and-so and council appearing for opposite party number so-and-so. Seek some time to respond to this petition, seeking implement of so-and-so in the petition. Let this matter, let such an affidavit, let the required requisite affidavit be filed positively by the next day, be notified after 4 weeks.
8 May. Item 14 and 15.
Okay.
Lordship, my senior Mr. HK Das is the amicus during this.
What is it?
Lordship, before the applicant starts, Lordship, my senior Mr. HK Das is the amicus curiae in this matter. Lordship, he's have to go out of station today. Kindly, the matter may be taken up in his presence.
No, we'll keep it after the election, sir. Let this matter come up for consideration. No, not will. Let this matter come up for consideration. After ninth ka committee election.
Thanks, Lordship.
29 April. Item 15.
May please your lordship.
804 days.
802 days, your lordship.
So 2 days difference. Yes, Mr. Nath.
But
Would you respond?
I'll file a small objection to it.
This so and so.
Deeply obliged.
Notice is accepted by Mr. Nath. Notice to the respondents accepted by letter counsel, namely so and so. Give your slips. All of them seek some time to respond to the petition, respond and oppose the petition. Let the requisite affidavits be filed positively by the next day, June.
10th June. Deeply obliged. For admission, item 17.
But on the last statement of the lawsuit, I acted the learning individual.
Yes, the woodcraft.
My lord.
Learned AG is not here. He had assured this court that he shall look into the matter, have the electricity bills and other things paid.
Electricity
Would
bills
also, and would also inform this court whether this building, this premises would be needed for that. And if it will be needed for what time? Let us adjourn it for some date in April, say by 20th of April, 20th, 22nd.
But if they need it, they let them acquire. Or temporarily
Now,
they
why
need.
do we suggest them?
No, I am saying, look,
They should vacate
they,
or pay you rent subject to your, they have fixed a very low rent.
look, the rent has been fixed by the authorities, my lord, as per the Assam urban area.
But that was reduced unilaterally.
12,000.
A very paltry amount of
That is
12,000.
12,000 per month.
All right. The learned AG who is to assist this court on behalf of the respondents is not present today, is not present.
Lordship, he is in code number 5.
He is not present. He is on legs in some other court. But let this matter come up for consideration on. Yes, sometimes in May. Sometimes in May, let the government be constituted and we'll see.
Well, if your lordship recalls that they should inform the court.
6 May. Item 18.
Affiliations, where is the letter? Where?
My lord, we have, my lord, annex to our affidavit, my lord. My lord can straight away can come to page, my lord, 236. My lord, the petitioner was the, my lord, principal of Karimganj Law College, my lord.
Give us 1 minute.
My lord, my lord.
Let us go through the order dated 19th of January 2026.
Not really.
The offendant was the principal of the college.
My lord, I was the principal, my lord.
You've been suspended and now.
Initially suspended, a DP had been initiated, my lord, and I had been terminated, removed from the service also, my lord. Now, my lord, in the two writ petitions, my lord, before the learned second judge.
After your removal, you have filed this petition that the deputy commissioner did not have the jurisdiction
No, my lord,
to
during
convene a
the,
public meeting.
my lord, during the time of, my lord, suspension, I raised that.
For the education department, for
My-
the Assam University and the education department.
My lord, Assam University is the council, my lord. Assam University.
Nobody is. I am a paper state. State doesn't have much. Very good.
Deputy commissioner is the main party, my lord.
No. You appear for deputy commissioner.
No, my lord. I was paying for higher division.
Who appears? We should know, no? Mr. Bhuyan, you should be aware who is to be
No, my lord,
questioned.
my lord, the name is showing, my lord, we have furnished the copies also, my lord. GA Assam is generally appeared for the deputy commissioner, my lord.
Who?
Government of Assam, my lord.
Who appears for the government now? So, Mr. just have a look at the brief. Yes, assist us on the next day.
My lord.
Yeah. Do I say that there is no appearance on behalf of the state respondent?
Well, it is, although I appear for the deputy commissioner, respondent number 4, but it's the education department. Higher education.
We don't know. We want the state entity to be here.
I will.
As prayed for on behalf of the respondents, we notify. Take time and tell us. He has questioned that the entire formation of the steering committee or the new committee, that power may have been with the deputy commissioner, but then the power to exclude all other persons from that committee and do whatever, that is what he has challenged. We had asked for the affiliation paper. That also perhaps he has brought on record. Just have a look at it and then answer. Now it's a government college. No, it remains an affiliated private college.
Private, my lord.
I will. Here, as prayed for on behalf of the respondents, let this matter come up for consideration. So and so. We were dating April.
Sure. 27 April.
Mr. Bhuyan, we are slightly uncomfortable with the idea of a person having shown the door and then coming and challenging the original reformation of the committee.
No, my lord.
You could question that.
My lord.
Even otherwise,
My lord.
even if it's a private institute, your rights and remedies are always available before the appropriate forum.
My lord. My
But
lord.
can you be permitted to question the powers of the deputy commissioner when this committee was formed? You never questioned that.
No, my
It was
lord.
only later when disciplinary action was taken against you, you have come here. Challenging the formation, challenging the contents of the powers, the contours of the powers of the deputy commissioner. I don't think you have a case. Anyway, let them answer. Why should we answer for them?
My lord. Obliged. Obliged.
Item 19.
Yes.
Very limited one, my lord, this, my lord, if it is fine, my lord. There is one, my lord, the OM, my lord, is there, not, is relating to outside allows. my lord.
One second. Who appears from Mizoram state?
My lord, Mizoram.
There must be an advocate.
It is an advocate, people, the MSP, what is it?
Where is she? It is, there is a 2017. There is a 2017 notification of the Union government where Mizoram is classified as dead category, with only 8%. Cat says that give them to the 16%. No, just take around. No. Mizoram is not even a party here. How come? What have you filed?
My lord is the cat order, my lord, is cat order is my lord.
Wait, why did you not impede the state of Mizoram?
Well, I'll implement, my lord.
Anyway, let notice. Is it coming for the first time?
First time, my lord.
Let notice be issued to the respondents. on steps being taken by the petitioner / Union of India and 5 others within a period of 3 weeks, both modes returnable on transfer. The learned counsel, counsel for the petitioner further submits that steps will be taken to implement the state of Mizoram also as one of the parties. As one of the parties to this petition.
High level. 6 May. Item 20.
Who appears for the petitioner? Appellant? Nobody appears for the appellant. Has now the license been given to somebody?
No, Lordship. It's not.
Still,
Not
there
yet.
is no, there is no IMFL shop at that place.
No.
No license.
No, the tender process has
So
not
by
yet started.
judgment, neither you nor the appellant,
Yes,
both of them.
both of them.
You're excise.
I'm for the excise, he's for the respondent.
Nobody appears on behalf of the appellant. The counsel for the respondent is present in the petition. The appeal is dismissed for non-prosecution.
Obliged, Lordship.
Just a minute, Mr. Excise Lawyer. Wait, this is coming for the first time. He is not here. Though on merits, we don't have much to say, but we'll give one more opportunity.
Very well.
Nobody appears on behalf of the appellant. The counsel for so and so is present. Let this matter come up sometimes in May.
Obliged, Lordship.
कौन सा कॉल किया? कौन सा कॉल किया?
21 Lordships, I appear for the petition.
Yes.
We are challenging the learned single bench order dated 12th of February. It is regarding interpretation of the word month under the GST Act. Supreme Court over a period has already interpreted that when a period is defined as a month and month is not defined in the Act, then reference is to be taken to the General Clause Act. 235 is defined months to be a British calendar month. And over a period, Supreme Court has given judgments, Lordships, wherein the corresponding date rule, if there is a month and if there is a date, suppose 28th of February in the present case.
So it has to be, if it is not specified that it is 90 days, then it has to be
3 months. And if that date is available in that month, then it has to be that one. Lordship, already 2 high courts, the division bench of the Andhra Pradesh and Telangana high courts, brought a compilation, has ruled that any notice after 28/11 for the same financial year.
So what difference does it make? 2 days, 2 days.
Lordship, it is limitation. It is
Less than 2 days.
Lordships.
Less than 2 days. If your interpretation is accepted, then the notice was filed.
It is time barred, Lordships. 73, it is time.
Mr. Gogoi, you respond. Respond.
That interpretation.
Respond. If you want to file an affidavit, you can do so.
Lordship, I am praying for an interim, Lordship.
Not at all.
Lordship, why, Lordship? There is a flaw. Why,
Mr.
Lordship?
Kanodian, no. Respond. Mr. B. Gogoi, learned additional advocate general has had seek some time to respond to this appeal. In case so deemed necessary affidavit may also be filed on behalf of the state. Re-notify. Do I say prayer, entering prayer is rejected?
Lordship, just one second. Lordship, because during the pendency of the writ petition, they passed an order, demand order. In the writ petition,
Challenge that order.
Lordship,
Challenge that order, that demand order.
Lordship, that is the subject matter now because the learned single
That
judge.
cannot be. You take that ground again. Here we are not for 1 or 2 days. Anyway, we are not granting any interim protection. That is, we have told you straight.
Lordship.
You want it to be stated?
No, Lordship, no, Lordship, not to you. Lordship, wait for you.
Adopt a different course. Challenge that final assessment.
Lordship, I am ready to pay.
You don't want your anything to be assessed because of the delay.
I want to pay 10%, Lordship. 10% I can pay.
You pay?
Lordship, I can record the Lordship 10%.
We are not recording anything. Let them respond.
Wait for you.
Item 23.
Proceed stage. Sub proceed कहाँ से मिलेगा?
Your Lordship.
Lordship, last date,
You want a working place in the association.
yes.
Who can assure that? Whom have you implemented as a party? Whom have you made the party?
The Guwahati High Court Bar Association.
Not a High Court, Bar Association, not High Court.
And the registrar general.
Registrar General would do nothing. Who is the president of the bar? Go and make a request. Why do we notice him?
Last time we offered.
What kind of writ petition have you filed?
Your Honor, I have come
There
across
are so
some
many advocates who don't, there are space constraint. And it is precisely for this reason that we are looking forward to the construction of integrated court complex where there will be 1900 chambers and 2 or 3 big halls.
but that does not streamline any rules for who would be allocated the chambers.
Rules we will see here. There are many things that the lawyers are there.
Lordship,
Go and request.
I have come
Who is the
across some
president of the bar? Is he here, Mr. Chaudhary? Mr. Chaudhary is the president.
I
Is
have,
the other office bearer of the bar association. Make a request.
Lordship, I have come across some new information which I would like to place before.
We are not inclined to hear that information for seat.
Just,
The difficulty is that it is simply not possible. No, not that.
just a week's time, I will
No.
place all the information.
As
that will
petitioner
happen, I
on
think.
behalf of the petitioner who appears in person, let this matter come up for consideration. Sometime. Which Mr. Smith? Sometimes in May.
22nd May.
Yes, Lord.
Whom are you appearing for? RG.
Yes, Lordship, on behalf of Mr. Ishwar.
RG has nothing to do. What RG will do in association?
Obliged.
Item 24.
What vague has happened? The petition is very vague for us to even issue notice. You have raised a whole litany of complaints. Nothing is focused. Out of corruption in society, funds being misplaced. What do we do? We have to, for you want an overhaul of the system. This is our goal. This is our intention. But for PIL to be entertained with this kind of material, you must supplement your petition with some material we can.
I will file an additional affidavit.
It makes no sense to us. What do we ask them?
Okay.
And we can't make a roving inquiry whether the allegations raised by the petitioner is correct or not. Do you understand our difficulty? You may be raising correct issues because you are one of them.
Yes. Additional affidavit, Lord.
Basically, they are against the contractor. Anyway, report at my time. $15 bills were paid and there was no assessment whether the work was done. The engineers like, yeah, no. Take time. Let them respond. Let them also be under some kind of. It's so big that we should not be doing it. No? That's comments too. Very good. Anyway, the petitioner is a local resident of Lala Development Block in the district of Hailakandi. By this petition, he urges this court to ensure that the 15th Finance Commission funds meant for village roads, schools, toilets, community halls are spent in a transparent manner. The contention of the petitioner is that in the financial years 2020 to 2023, there were 15 specific developmental works which were carried out in different gram panchayats under the Lala development block. So these works included repairing of Anganwadi centers, repairing of school buildings, construction of community halls, cremation ground, public toilets, and other small infrastructure projects. The grievance of the petitioner is that all these 15 works were officially allotted to two of the favorite contractors, namely Messrs. MG Associates and Sri Monojit Devnath, who have been impleaded as respondents number 6 and 7 in this petition. This, the petitioner realizes, would not have been enough for urging the court to take notice of the matter in this public interest litigation. However, it has been submitted that collusively, the aforementioned two contractors were paid full amount against their bills without even verifying that they had completed the work. There was no certification by any accredited engineer. And most of the works remain incomplete. The petitioner has based these allegations on his personal information, as he had himself worked in one of these projects, but was not paid his wages. It was only in the context of his inquiry as to why, despite the contractor having been paid against his bills, the workers were not paid, that he came to learn about these anomalies in the public fund spending. Hence this petition. We were tentatively of the view that there were no specifics in the petition requiring us to interfere in the matter. But considering that huge amount has been paid without ensuring that work has been completed, we consider it necessary to ask the respondents to explain. The notice to the respondents is accepted by MS Mr.
As Dr. Madam.
MS Sumitra, learned advocates for the state, who shall respond to this petition by the next date, June.
Extra copies will be served.
Serve
Yeah.
copies.
Okay.
Serve 2 copies to 2 of them. We have saved you from spending on notice expenses requisites. Give them 2 full copies.
Sure.
And also obtain a copy of this order. Give a photocopy of the orders to them.
12 June.
Obliged.
Item 25. Yesterday we were about to dismiss the petition. Not yesterday, day before yesterday. We were about to dismiss it.
Sorry, my lord, there are 2
Yes,
cases.
But we knew that somebody or the other would be appearing.
Yeah.
It's a 2013 matter, no?
My lord,
Recruitment process began in 2013. Why do we interpret?
my lord,
Just a minute, give us a minute.
What benefit are you getting, Mr. Counsel? Even if the APDCL makes a verification of the appointees of 2013, that has already been done. They are serving for the last 11, 12 years. You don't fall in that category. You applied under category A, ITI. Can you challenge, in fact, when the single judge held that it was permissible, when the single judge held that your petition was hit by delayed latches, there was no necessity of going into the further matters. And how could you question? You don't say that you have wrongly been ousted. Do you question that? No, you say that people in category B, they have wrongly been selected. Can you question that?
No, my lord, not that, not only being selected.
That is the contention.
That, my lord, what happened, my lord, we have.
2013 matter.
Yes, ma'am, everything, my lord, in fact, this judgment in the single judgment, there was a judgment of this honorable court, division bench, where this issue has been raised, the same issue with regard to experience
No, my lord,
certificate
different
anomalies at rate appeal 274 2021. And the learned single judge, after looking at the judgment, has observed that therefore, in the light and directions contained in the order dated 24/1/2023, filed with the division of 274/2021.
There is only one issue.
Yes, my lord.
These
Yes, and this exercise has already been has been over. Yes.
No, after the judgment, you
Yes.
did an exercise of finding.
Yes, we have recurrent, the exercise has been
And
already
you
been.
don't find any anomaly.
My lord, the person who had got anomalies, they have been taken out, and the person who has been.
We are recording your
My
statement.
lord.
We are dismissing this appeal.
My lord, I may be pardoned. What happened, my lord? We have challenged there are two categories of the, my lord, candidates. One ITI candidate falls A category, and that ITI candidate should be have been passed minimum HSLC, my lord, matriculation. And another category, my lord, B category, my lord. My lord, another B category candidates was given relaxation, having 3 years of practice in the working field and.
First name.
My lord.
Now, is it going to improve your case so far as your candidature is concerned?
No, my lord.
Was that in your category?
My lord, it is not distinguished in the
What are you
advertisement.
doing now?
My lord,
After
that the
2013.
illegal person, my lord, and serving, my lord. Clear violation of the advertisement, my lord.
Violation
My
of
lord,
advertisement, we don't see it from your end.
I may place before your lordship 2-3 violations.
We
Suppose.
will permit you to. Normally, we hear everything, but we will not permit you to. That is what the law mandates. I don't know why the learned single judge, kept the issue open. Especially when it found that, when the court found that your petition was hit by latches. There was no necessity to question the correctness. And then why? Somebody who has been appointed in 2013, which appointment is being questioned after so many years by a petitioner who had failed, who had appeared in a different category where he did not pass. Now, should it have been done?
My lord, in this regard, my lord, whether the, my lord, unqualified person can, my lord, wrongly or inadvertently appointed. My lord,
Okay, can I say? Try and understand. I don't think I am using a language which is not intelligible. We said something to you. Why don't you understand? You are an ITI pass out.
my lord.
For ITI pass outs, there was a separate category of A.
Yes, my lord.
There were others with experience.
Yes, excellent.
So the posts also were delineated. For category A, so many posts. For category B, so many posts.
No, my lord, that was not.
Otherwise also. forget it. Now, in the year 2013, this examination was conducted. You took the examination, others also took the examination. You failed in category A. All the appointments that you challenge now after so many years, after getting wise by some RTI disclosure, you say that people appointed in category B were persons who had filed forged or false certificates of their experience.
Yes,
Later, it was found that that was not false, just that the concerned authority had not signed it. But over a period of time, before giving appointment to them, they were countersigned by the correct authority. Even otherwise, the court felt that APDCL should conduct an inquiry, that they have those who were wrongly employed, they have been shown the door. Now, what locus you have to pursue this?
No, my
I
lord.
don't
In
understand.
this case, my lord,
I request to write the judgment.
My
of
lord.
the order.
only I may be allowed to place. My lord, only one place, my lord, so
Mister, you are employed, presently you are employed or unemployed?
unemployed, my lord.
Unemployed. Therefore, we are restraining ourselves from imposing cost to you. And is this litigation? It should not have been entertained in the first instance.
My lord, only one page,
जो बोला
page,
5 मिनट में खत्म
page
करेंगे।
170, my lord. Page only 170 page, only one instance. I will, Lordship may produce only page 170, my lord. What happened, my lord? 3 years practice required, but here only 9-month practice, my lord.
Yeah, I'm trying to discuss all these repetitions, not one, hundreds of repetitions raised with fail together. And at the end, direction was issued to have a verification because court could not do all this. Lakhs of candidates. Then the verification was done, in fact, you are not with those judgments. Subsequent judgment.
Yes, my lord.
Yes,
Yes, my lord, lordship's own judgment, yes.
I myself.
Yes, sitting alone, yes.
Take it, my lord. Yes, my lord. If verification done, my lord, only thing, my lord.
Implied है इसीलिए हम
My lord.
I'm hearing you, but this is not going to fetch you employment.
My
Number
lord,
one.
only
This is no public
my
interest
lord,
litigation.
lordship may
Number three, we are slightly skeptical of imposing cost on you. You yourself are a young advocate. We don't want to trouble you, but I said, don't hold us back like this. It's a absolutely, non-maintainable petition which has been in which there is some parenthetical remark by the learned single judge that we don't even take notice of that.
My lord, there is no delay. We have filed in the petition in 2013 itself, my lord. 13 itself. subsequently that was withdrawn with liberty, and we have filed before. My lord,
13 with liberty and you filed this petition.
not my lord.
Conclude your-
No, not my lord, 24. 15, my lord. After getting the my lord documents from RTI, my lord. After getting the documents, all the qualification certificate and experience certificate on RTI, I have, my lord, included the selected candidates and filed this, my lord, petition in 2015, my lord. So, my lord, what happened, my lord? Some are minor or engaged. Some are, my lord, what happened, my lord? Experience. Some are, my lord, class 8 requires, but not past class 8, my lord. Completely against the advertisement. But how they have inquired, my lord, about how they have inquired, my lord. In fact, in 2015, we have filed petition that the social candidate is minor, so and so candidate not having, my lord, experience, so and so candidate has not requisite qualification. In the year, my lord, 2015 itself, but they are serving, my lord, till now. And they have, my lord, reflect that we have verified. If verified, my lord, till date, a experience holder of the 9 months is serving, a minor is serving. How they have, my lord, verified, my lord? Take it.
We have heard Mr. M. Hosnain, learned advocate for the appellants, and Mr. S.T. Sharma for the respondent APCF. APDCF. The Assam Power, पूरा लिखा Assam Power Distribution Company Limited, bracket में APDCL. The APDCL had issued a public advertisement sometimes in the month of April 2013, inviting applications for 1,064 posts of Sahayaks. the advertisement clearly divided the posts into two separate categories, namely category A, which was meant for direct recruitment for ITI pass outs like the appellant, and category B for experience older temporary workers who had worked for at least 3 years in any power utility. The appellants, being category A candidates, had applied against the advertisement, appeared for physical fitness tests, and also participated in the interviews. First up, a re-examination was held after the first round of examination was cancelled, in which also the appellants had participated. And according to their estimation, they had performed well. However, their names were not included in the select list published on 21st of February 2014. To their dismay, surprise, and chagrin, the appellants discovered that many of the category B candidates who have been implemented as respondents number 8 to 70 had been selected. Information gained through RTI mechanism made the appellants understand that the respondents claimed experience on the basis of certificates which were not issued by the competent officers, namely the assistant general manager of the power utility, which was the specification in the advertisement. Some of the certificates relied upon by the respondents were only experience certificates of 9 months, and some of the certificates were of persons who had not come of age of appearing in the public examination. There were many, according to the RTI information to the appellants, who had not even passed standard 8, the minimum qualification required for category B. Some of the documents furnished by the respondents were either issued or attested only after the last day of the application form. These are the grounds. Last date of application, which was 30th of April 2013. The challenge of the appellants to those appointments failed. The contention of the appellants is that the irregularities pointed out made the selections of the respondents absolutely illegal, arbitrary, and violative of the provisions of the Constitution of India. The contentions were, these contentions were sought to be negated by the APDCL authorities on the ground that there were two categories of applicants with different streams, and the appellants being of category A did not have any locus to challenge category B selections. Further on merits, it was argued before the learned single judge, as also before this court, that the certificates of experience, which was filed by some of the respondents, and which certificate had not been signed by the appropriate authority, was later permitted to be rectified, and the appropriate authority certifying the experience ultimately signed those certificates. The learned single judge found that the writ petition preferred by the appellants therein was hit by delay, was not maintainable. There was though maintainable, but the allegations were such that it could not have been acted upon. Apart from that, the learned single judge found that earlier a division bench of this court had directed the APTCL authorities to conduct a fresh verification exercise with respect to such appointments. And if any category B candidate was found to have submitted qualification or experience documents after the last date of filing the application, namely bracket 30th of April 2013, or if any experience was gained while the candidate was a minor, those appointments would be required to be treated as void from the beginning and terminated after giving notice to them. The resulting vacant posts would then be offered to the next meritorious candidates, which might include the appellants if they fell within that merit zone. However, the learned single judge rightly chose not to quash all category B selections outright and left the verification process to the authorities without fixing any time limit. Mr. S.P. Sharma, learned counsel for the APDCL submits that pursuant to the aforementioned division bench judgment, a thorough exercise was conducted, and some of the appointees in category B whose experience certificate or age were found to be faulty were removed from service. That exercise having been done, and the rest of the respondents continuing in service till 2000, from 2014 till date, there is no reason why this appeal should be entertained at the instance of the failed candidates of category A. We find no merit in this appeal, and thus we dismiss.
My lord, only my submission. My lord, I say
Next.
only one submission, my lord. My lord, they have submitted that we have verified and terminated, my lord. Only that was submitted in another case in contempt is only 6 person regarding only, my lord, issuance of certificate, non-valid certificate.
Persistence is good,
And-
Mr. Hasnain, but not this
But
way.
those person are
Yes, next, call up next.
minor are not, my lord, terminated.
Next.
Item 27.
May I please have lordship?
Yes.
This petition is directed against an order passed by the learned CET lordship. Your lordship will find at page 154. So the basic facts, lordship, are that pursuant to the 6 CPC, there was a pay fixation. And there was a mistake in the fixation of the respondent's pay. Not only the respondent, the class of employees, there was a mistake, and for that mistake, they had received excess amount. And by the interim orders before the learned CAP, the excess amount which was paid, that was sought to be recovered, and the pay was sought to be refixed, which was to be the actual pay. Now, so far as the interference of the learned tribunal as regards recovery is concerned, Lordship, I will not make any submission, because whatever has been paid by mistake has been paid. But then the fixation, what would be the correct fixation, that the authority has the power to do, Lordship. I am only on that. Now,
Come now. As fixed. It's coming for the first time, no?
yes,
They have not issued notice.
no,
Now let us formulate the issue and then issue. We have heard Mr. R.P.D. Chaudhary, learned advocate for the petitioner / Union of India and others. The challenge in the present petition is to the order passed by the Central Administrative Tribunal, bracket CAT, Gauhati bench on dated 22nd of May 2022. Next. The respondent employee was appointed as assistant loco pilot in the year 2002 and was promoted to senior assistant loco pilot in the year 2006. After the Sixth Pay Commission rules coming into effect in the year 2008, his pay was fixed at a certain level. Stop. It was in the year 2021 that the railways discovered that this fixation was wrong in as much as one mandatory increment had not been applied correctly as per the railway board's instructions. The pay of the respondent employee was therefore refixed downwards with effect from 2006, thereby reducing his basic pay from rupees 78,800 to rupees 72,100 as on 1st of July 2021. The employer / railways also directed for recovery of excess amount paid over a period of 15 years. This was bad. You should have done that. You have found out something.
Lordship, I have,
Rafiq Masih and many other cases.
there are n number of
N
cases.
number of cases.
I have informed them.
But very fairly you have said that. We are happy at this. What have I said? What have I said? "15 years, which amounted to approximately rupees 7 lakhs in 60 monthly installments. So in fact, as ever in the papers, some recovery to the extent of rupees 70,000 and odd has already been made from the salary of the respondent employee between September 2021 and March 2022. It was at this stage that the respondent had approached the tribunal on the strength of the judgment of the Supreme Court in State of Punjab versus Rafiq Masih, citation level. The tribunal has quashed the refixation has quashed the orders of refixation and recovery and has directed the petitioner / railways to restore to the respondent his original higher pay of 78,800 and refund all recovered amounts within 4 months. Mr. R.K.D. Chaudhary, while assailing the order of the tribunal, very fairly submitted that the recovery of excess payment from a Group C employee after so many years would not be a correct exercise. But so far as correcting a wrong pay fixation is concerned, that ought not to have been stopped by the tribunal. The further contention of the petitioner is that such corrections have been carried out in cases of 48 other loco running staff. Restoring the higher pay to the respondent would, if not anything else, create a serious anomaly. Let notice be issued to the respondent on steps being taken by the petitioners within a period of 2 weeks, both modes returnable on so and so date, sometimes in June, till such time the order in June, the order passed very well. No, still. Till such time, the direction of the tribunal to restore the basic pay of the respondent at rupees 78,800 as on 1/7/2021, as fixed earlier, shall remain in abeyance.
5/6, 6 June.
Stop. We have to make it very clear that there should not be any recovery from the salary of the respondent.
In fact, if your lordship will permit, there was a conference of the central law offices last month. And this is an issue which is coming to me every day from various departments. And the excuse is the directions are from Delhi. We cannot do that. So I pointed it out to them.
Right. Yeah. Yes,
6 June. Item 30.
item.
The internal file issue notice of motion here. Of the interim payers returnable and the services completed.
So the respondent, this order has to be modified. AFTC's order, we are not comfortable with that order. This is something. RMD's report has been given a go by and of his own on, I don't know which. We are awaiting the appearance of.
His name is shown. In fact,
Where is Mr. Tabildar?
in fact,
The
this
council-
same issue is pending for losses and fixed in the month of May. In the interim,
Swami, this London Central Government Council, London CGC is present. There is no appearance, Mr.
similar order to this, maybe.
There is no appearance on behalf of the respondent who is being represented by Mr. So Mr. Tabildar. Learned advocate. Yes. The learned CGC has pointed out that under similar circumstances in WPC number 839 of 2024, the same order, under similar circumstances, the order passed by the Armed Forces Tribunal giving the rounding of privilege to a retired employee and directing for payment of disability pension to the extent of 50% has been directed to be kept in abeyance. considering this aspect of the matter, the order passed by the armed forces department shall not be acted upon till the time of disposal of this writ petition.
For me, I think it must some region order. If those orders, these are.
Oh, these are single matter, you also take up the matter, these are speaks in matter.
That's why we have given reasons. Then we only say, Mr. CGC is present, you're right. This is just a stay, this is not by us.
Mal,
We have passed and reasoned a stay order.
mal.
Yes, and we let this matter come up for consideration. Other matters on 13th. 13. Inform Mr. Kabila.
Mal. Well, the interim pair, already.
We have said.
Mal, highly of
Yeah, we will get up. Kitna matter bachta hai? Bahut hai. Bahut hai.
Item 31.
Yes.
I mean, here it is, you know. If it is came for the first time. One of this,
I mean, for the first time, but you'll have to make out your case for us to issue notice.
my lord, this writ petition was dismissed on the grounds at page 98, my lord.
Give us 1 minute. You had not completed the appointee for the writ court.
My lord, after that,
That was the curable.
in I for condemnation of delay, my lord, your lordships had passed this order in I 2297. Your lordships were gracious to, my lord, allow the implement of the selected candidate as respondent number 7. My lord, my lord.
You could pass the written examination, no?
My lord, he had secured 43%.
So pass was 50%.
50%.
Mr. Sharma, you are not a performer. You're not a performer.
My lord, I've been,
You're getting persuaded to issue notice also.
my lord, I've been in service since 2004.
That's all right. Experience doesn't count for everything.
After 12 years, my lord, after my lord, this honorable court had directed the due weightage to be given to my past performance. But I leave it to my lords because my lord had already graciously allowed me to imprint the selected candidate as a respondent 70 deputy itself.
That's the only ground why we will issue notice. Not on merits. If we had examined the case at that point of time, we would have said, no, not necessary. But here, let notice be issued. Anyway, here, the appellant is aggrieved by the judgment passed by one single judge of this court dated so and so in so and so. Primarily on the ground that the writ petition preferred by him was rejected only on the ground of a curable defect of the appointee not having been impeded as a party respondent. Next. The appellant was initially engaged as a temporary copyist in the office of the District and Sessions Judge Nalbari, Assam, in the year 2004. His engagement was extended multiple times, backed by government sanctions, but the post remained temporary, with no guarantee of regularization unless he appeared before a selection committee. Before that, in the year 2011, the services of the appellant was transferred to the newly created office of the presiding officer / member motor accidents against tribunal, MSCT Nalbari. In MSCT Nalbari, the appellant claims to have gained significant experience, especially with respect to case information system. He performed the duties of a regular copyist for over 12 years. He therefore had a legitimate expectation of his services being legitimate expectation of his services being regularized. Next, it appears from the records that in the year 2011, the MSCT office advertised vacancies, including that of a copyist, with the condition that the candidates with judicial experience would receive due weightage. The appellant applied against the advertisement. However, because of a written test having been introduced, in which 50% marks was set as the benchmark by the selection board, the appellant could not make it, for him having secured only 43% marks, which was below the threshold marks. The first of the contentions of the appellant is that the advertisement process was that the recruitment process was changed midway by the board, requiring a written test. This, in fact, has in turn resulted in denial of weightage benefits to him. Since he did not cross the
threshold benchmark, no weightage for his experience was given. In, in the background of such contentions raised on behalf of the appellant, Mr. Sarma Leonard Advocate urges that the learned single judge ought not to have dismissed his writ petition only on the ground of the defect of the appointee in the process not having been. He could have been permitted, the appointee could well have been permitted to be implemented. Be that as it may, in this appeal, he challenges the change in the process of recruitment midway and resultantly no weightage having been given to him, notwithstanding the fact that such was an indication in one of the writ petitions preferred earlier, as also his actual experience gained, which actual experience gained with the case information system. Let notice be issued to respond number so and so, respond number 7 on, let notice be issued to respond number 7 on steps being taken by the appellant within a period of 2 weeks, both modes returnable on once a day. The notice to the other respondents is accepted by Ms. Petson. Evening.
Guwahati High Court may be reflected in the cognizance. Pending.
Guwahati High Court panel party. You've made Guwahati. The name of the standing counsel for High Court of Guwahati also to be reflected in the listings.
Much obliged.
18th May.
I was about to dismiss this, Mr. Sharma, but our own mistake of permitting the implement in an IA without hearing it with the merits. Anyway,
Item 34.
Yeah, this matter may be fit for hearing, right? Because we have assailed,
yeah, what is the status of the State Safai Commission?
My lord, sure.
Anyway, let this matter come up for hearing. On so and so.
4 June 46. Item 35.
Deposit objection.
Lordship, the
Mr. Bhatti, pre-deposit objection. Arey, you're not understanding what I am saying.
Yes, my lord.
आपको hearing aid लगाना होगा. मैं आपकी point बोल रहा हूँ. Pre-deposit restrictions is what irks you here. Anyway, what do you want?
Lordship, the matter may be taken up at 2 p.m.
Why?
Lordship, there is some difficulties on my senior's part.
All right. At 2 p.m.
In that case, my lord, this matter may finally be taken on Monday. Because I have some difficulty
Yeah, prayer for
in checking
Passover
out.
has been made on behalf of the respondent. Mr. Bhatti led an advocate for the petitioner. No? Mr. Bhatti led an advocate for the petitioner. However, has some objection, has some difficulty in the second half, some difficulty over the day. Let this matter come up for consideration on Tuesday.
Much of
24th. 24-3. Item 36.
appears? Who appears for the respondent?
Yes, my friend is appearing, yes.
Yeah, so you seem to be a great litigant.
Yes, my lord.
Yes,
There are this is the 5 times litigation, and each, in all the 5 courts have,
you retired
I,
long time back.
yes, my
You
lord.
slept over the
I am
other
the-
for 17 years.
Yes.
We
In
are
all
not
the time, court has given me the promotion.
inclined to sustain the tribunal's order. After 17 years, you have retired. Now you want the benefits of the account stream. Sorry,
Yes.
we are not inclined.
I am a victim of the system, my lord.
You're a victim of the system, or system is victim of your machinations.
No, my lord.
How many times have you been suspended, grade lowered? How many times? And then when when the tribunal had passed an order 17 years ago, you did not file any application for its execution or contempt or anything of that kind. That means you capitulated. You were ready to work in the in the side of the administration. Are you aware of the facts?
No, my lord.
आप तो फिर कैसे पास करेंगे? So many barrage of questions from the court. How do you answer? You are just shaking your head. I could understand. Therefore, I'm asking you this.
Whenever the promotion, question of promotion comes, I have been
आपको
victimized
टाइम
by,
चाहिए तो मैं टाइम दूंगा. I am asking you so many questions. You're not responding effectively. Therefore, I asked you, are you prepared? We have disclosed our tentative opinion unless you dislodge this opinion of ours that the order of the tribunal is not worth sustaining. You'll have to do some work, homework.
okay.
तैयार होइएगा.
Give me time.
Huh?
Okay.
Not, मैं नहीं चाह रहा हूँ आपको देना. We are ready to dismiss this, to allow the petition of Mr. Chakravarti. आपको चाहिए नहीं चाहिए टाइम?
Give me time.
तो पहले क्यों नहीं मांगा? we made some observations that you're a great litigant, तो आप कहते हैं yes. फिर हमने कुछ पूछा तो फिर आप कहते हैं yes. That gave me the apprehension that you're not facts. चलिए कब चाहते हैं?
2 weeks.
2 weeks of hearing. ये कैट के ऑर्डर को इसको स्टे करेंगे अभी. We'll have to stay this order. This cannot be implemented. तो बड़ा मुश्किल है. Pursuant to the notice, that 7th of January 2026, Mr. D.N. Sharma, learned advocate, has appeared for the respondent. The challenge in this writ petition is to the order dated 4th of June 2024, passed by the Central Administrative Tribunal, Gauhati bench. In OA number 167 of 2020. In which a direction has been issued to the petitioner/department to give to the respondent notional promotion benefits in the accounts cadre as per a 2001 CAT order, and to pay him over and above rupees 20,000 as cost. It appears from the records that the respondent had joined the Postal Department on 9th of June 1964 as a time-scale clerk. He rose to the rank of Inspector of Post Examination in 1972. And thereafter worked in the administrative line. However, during his service tenure, he had claimed that he had passed the P&T Account Service Part 2 examination
in the year 1975. But because of departmental proceedings pending against him for good 10 years from 1975 to 1985, he could not be posted in the line of accounts, a different stream than the administrative site posting. The respondent continued in the administrative stream, and in that stream he was promoted to the post of assistant superintendent of posts in the year 1985. So thereafter, the respondent was appointed Postal Service Group B gazetted category in the year 1996. He retired as senior postmaster, Silchar Head Post Office on 28th of February 2005. If there is any anomaly in the dates, please let us know. Before he had retired, next paragraph, before he had retired, two departmental inquiries. In the two departmental inquiries initiated against him, he was found guilty of misconduct and was served with two penalties of withholding 15% of his monthly pension for 2 years and 5 years respectively. The aforementioned penalty orders were approved by the tribunal, were upheld by the tribunal in two separate cases.
One is still pending.
In two separate cases, when the respondent had challenged those before the tribunal. Those orders were challenged. Those orders of the tribunal were challenged by the respondent before this court also via petitions. Another fact which is required to be noted here is that in the year 1999, the respondent had filed an application before the tribunal by OA number 135 of 1999, demanding promotion in the accounts cadre. In that instance, the tribunal, way back in the year 2001, had directed the department to consider his claim. The challenge to such order by the department / petitioner before this court was dismissed. However, the respondent did not make any clamor, did not clamor for consideration of such a request, notwithstanding the order passed by the tribunal and upheld by the High Court. For about 17 years, neither did he ever represent for the implementation of such order or filed any contempt proceeding.
Here is a representation, my lord. I can.
You filed a representation.
Yes.
What
I
did I
can
say?
see all these things.
And you sat tight, you slept tight over the matter. What did I say?
There is so many representation and there is a reply also from the department. I shall think.
So 17 years. Kept on going for 17 years. You never came to the court.
Yes, my lord.
So,
There is so many
all right. Tell it up.
correspondence.
Notwithstanding this one, so except for filing representations, which were perhaps replied by the petitioner in the negative. No contempt petition was filed, nor any writ petition was filed to effect such directions in his favor. In the year 2018, the respondent appears to have filed a representation and then an OA bracket OA number 46 of 2019. In that OA, the tribunal directed the department to pass a speaking order. The petitioner/department rejected the claim of the respondent for giving him notional promotion in the accounts stream, primarily for the reason of his having voluntarily chosen to remain in the administrative side for so many years and having enjoyed all the benefits in the administrative line, as also for the reason that the records of the respondent.
Just a minute. While in the year 1982, all the disciplinary proceedings have been settled. Then they post me in the IPO line, this is administrative line, instead of giving me in
That's
the
what-
accounts line, which is
That's what we have said.
this is mentioned. In the year 82,
The
OA.
respondent again filed a fresh OA. Bracket 167 of OA number 167 of 2020 in the year 2020, challenging such speaking order by the department. That OA was decided on 4th of June 2024 by the tribunal, allowing the application and directing the department to implement the 2001 direction with all consequences, with all consequential notional benefits within a period of 2 months. अब तो बहस हुई गई तो इसको रिवर्ट इस ऑर्डर को सेटिसाइड करते हैं. आप और बहस करनी है और भी बहस इस फैक्ट्स के अलावा और बहस करनी है तो समय दें, अदरवाइज इतना मैं इस ऑर्डर
yes, my lord, I shall give you the some explanation in this.
Mr. Sharma, learned advocate, for the respondent, seek some time to seek some time. Seek some time to address this court properly on facts. However, looking at the nature of the order which has been passed in an OA, which has been passed in the year 2024, in an OA which was filed in the year 2020, we deem it necessary, in the meanwhile, to stay the operation of the impugned order. Mr. List this case on June में रखें? ठीक है. इसलिए
9 June. Supplementary list item 40 and 41.
ये सब खत्म हो गया.
My lord, item 41 we taken, my lord, fast, my lord.
What happened?
Item 41 we taken as a fast, my lord, because it is the interlinked matter,
Item number 41.
my lord. Yeah, my lord, in the nutshell, very briefly, I like to apprise your lordship is that, my lord, petitioner was appointed as an assistant professor. Lordship.
This reflects that you are very well prepared.
My lord, several times, my lord, the adjournment was given.
Yeah.
Lordship.
It was really good. Yeah.
Fast order, my lord.
Hearing right.
That your lordship will see at page 60, whereas we are not part.
Mr. Barbara, you are appearing for the person who has been displaced.
My lord, respond number 7.
Correspondent number 7.
Ajay,
He has been displaced.
Case.
You have won the order.
And other India.
By virtue of the order impugned, you have got your services have been provincialized to the, he has been elbowed out.
Yes.
That's what the government did. I didn't challenge anybody. I was bothered about, let me be very frank, I was bothered about my non-provincialization have a look at the.
Have you been removed from service or you're getting?
No, my lord, I have
Wait.
been issued, I have been removed, my lord. They have withdrawn my provincialization. Despite the fact that, my lord, I was eligible and I was not a party also, my lord. That's why I filed an IA.
I was not provincialized. I filed contempt. It came before my lord, number of single benches, my lord. Everybody asked government, why are you not provincializing me? Why are you not provincializing? Then ultimately, I was provincial.
If the lordship give me 5 minutes time, my lord, I'll bring the facts of the case.
And I was provincialized a year ago.
I was not made a party also, my lord.
Yes, please.
My lord. Lordship will see page 60, the first order filed by the last. It would, affidavit will fill up. Page 2 lower, page for the. Appellate of the. Appellate.
171, 62 question, like 176.
Oh, second case. Page number.
Yes, Mr. Kenneth.
My lord. Lordship will see the page 60 first, my lord, that they have filed a writ petition.
Page,
Page 60, my lord. There we have not been made party. Operative part lordship will see at page 63, my lord, paragraph 12.
yes.
Operative part lordship will see.
Yes.
Operative part lordship will see page 63, paragraph
Let us see
12.
what was, what is the Bora was the context. Give us 2 minutes.
My lord. What is operative part? Yeah, we have taken.
No, no. Sir, it's really surprising that even when the name of Fatima, can I know?
Yeah.
Fatima Chetia has been taken by the learned single judge and no notice was issued.
No, my lord, I was not a made a party also, ma'am.
And then this order has been passed.
Then order has been passed on the
Good,
strength.
bad, indifferent, we don't see the reason, but and it was in the conscience, it was in the contemplation of the learned single judge that with this order, one of the appointees, one of the persons whose services have been provincialized will have to be elbowed out.
Ma'am,
Now, if this was the case, then perhaps without notice, this order cannot be sustained.
no.
No, this order cannot be sustained. Mr. Borbora, this order cannot be sustained.
My lord,
On the sole ground of the notice.
I'll only refer to two documents. I
ना,
filed,
इसको बताइए ना, document से क्या मतलब है? You tell us on this,
my lord,
prime officer.
that's right. Government might have,
Let it go to the document. Let it go to the single judge.
government, lordship may remand it.
Yes,
Till then, my lord, stay has to be, my lord, my bread has been
There is
snatched
a
away.
composite order, my lord.
that we will that we will request the learned single judge to decide.
Ah.
But in the meantime, we can't snatch bread and butter from Mr.
My lord,
Borgohain.
I am, my,
We will say that it is expected that within 2 months it's.
My lord, kindly
Yes.
read paragraph 4 of the judgment.
Please, why do we go beyond
Yes.
all this? Mr. Is it-
stay I borrow.
I was worried about my provincial.
Mr. Borgohain, I think you'll have to suffer for 2 more months. We are
Lordship, I am living up to your lordship.
We are directing the land because we can, and on this basis, the another writ petition has been dismissed.
Yes, ma'am. My case was dismissed.
And nobody filed intervention petition, impleading petition, review petition, neither government nor him. Although, my lord, the implementation of this order took 1 year. I filed contempt.
Prime officer, this order is not sustainable.
Lordship,
In the motion stage itself.
no.
They file affidavit, my lord, they are claiming.
My lord, they are not reading.
Government.
Yes, government was there. Government didn't go for review. Government submitted that there are 4 posts. 4 could have been jolly well accommodated.
One has to be careful. If somebody is to be thrown out, he has to be heard
My lord,
for whichever reason.
one more thing, my lordship, kindly permit me, my lord, material facts was suppressed before the honorable single.
That you can file affidavit now.
Yes, yes.
After remand, you can raise also.
Yes, my case
Hearing
also
was given.
clapped together. ma'am.
Both the matters are remanded with the direction.
Lordship, lordship.
No, both cannot.
Both has to be, my case has to be.
दोनों को remand. Remand करेंगे, second वाले case के पास, इसीलिए उसी तरीके। We are remanding both the matters with a request to the single judge to hear and with a direction to the registry to place it before the court.
I think both cannot be, my lord. The
Both.
first one,
Because one judge has retired, the other judge has relied upon that order, therefore both will have to. be.
other is the retaken. Other is the retaken. That your lordship. 175 can be, 176 can be remanded.
So once we have the first method, the learned single judge, nothing survives to be adjudicated in the second.
That's
That
right.
that will clarify.
Remand, you withdraw the second.
Lordship, with the liberty.
Let-
41 be withdrawn.
So both remedy cannot, both form cannot be.
With some observation be given, my lord. Lord,
We will say, we will issue the direction to the registry to list it before court because now.
whichever
the roster has
is.
to be, and we'll say that before,
So
before the king.
ultimately, the subsequent order issued in her favor is subject matter of the first writ petition.
My writ.
That's all.
Yes, ma'am. My second read petition, my lord, sorry.
Second writ.
Second read petition, the first goes, second automatically goes.
And we.
Then observation be given,
View of this remand, you withdraw this appeal.
my lord.
Actually, that appeal was condonation. I gave my lord concession.
Not
Admit it.
concession.
1300 day
Let it be
delays.
decided, so we are prepared otherwise.
They have filed the objection, honorable court granted.
What difficulty, Mr. Borgora, is you would have set aside that order passed by the learned single judge earlier. But then that makes you, that puts you in the same position as Mr. Borgohain.
Yes, then
Lordship.
So
yes.
therefore we are remanding.
My
it.
lord, I frankly say, in implementing the single judge's order is not at fault. The government, my lord, director made a mess of it.
We don't say that. When we are finding fault with ourselves. Without notice, we could not have passed this.
No, because I never challenged.
Vote can be accommodated well and.
Yes, that could have been done. That could have been done, my lord. I don't derive any sadistic pleasure.
Law does not say so, my lord, fourth post.
All right. So one we are remanding, the other you are withdrawing.
41 be withdrawn. With the some observation be given, my lord, otherwise it will affect me before the honorable. Lordship.
All these questions, including the subsequent order.
Everything shall be considered by the learned.
Here on merit, single judge.
On merit.
Apart from that, we will request the learned single judge to give you a hearing and finally dispose of the matter within a period of 2 months.
Yes, ma'am. Till then, my lord, it has to go, my lord. Satisfied has to be done, my.
No, that we are not disturbing. There cannot be any.
Composite order.
There has to be a status quo.
First order will interfere, and then status.
Status quo, my lord, they will get benefit, my lord. That status quo is not required,
We can't put it and status quo ante and.
my lord. Lordship. The second one I have withdrawn, lordship, give some of that.
Total observation.
Lordship. Lordship, I am very obliged.
Sports actually. But it has only been this, I think. Check. But it is. You've got 37 or 38?
38, Lord.
Which was, yes.
Make his lordship. Lordship, the learned advocate generally appear in this matter, lordship. He's on license court number 5 in a special division bench matter which has been considered only for today, lordship.
Which is that matter? Which is holding back?
Lordship, NIA versus Okhil Gogoi. NIA, National Investigation Authority versus Okhil Gogoi, lordship.
Okay. Okay.
Since morning, that matter has been going on, lordship. Lordship, some accommodation, I prefer some accommodation, lordship.
That is DB1, the DB2.
Lordship, special division bench. Only for this matter, lordship.
One.
Justice
The bench
San-
comprises who?
Justice Sanjay Medhi and Justice Mridul Kolita, lordship.
Your lordship may give a tomorrow, day after tomorrow. He'll be available.
That's all right. We'll keep it after elections. After being.
Definitely too long.
No. What difference is it going to make? Who is getting disqualified? Who are you defecting?
No, I'm not defecting.
Then-
Because the matter is division
Everything
by
is
judgment is there.
Let
Two
it come.
division judgment is there.
Division by judgment we have to examine.
I can give it to your lordship once I can provide.
We are aware of the judgment. We are aware of that judgment.
Yes.
This is, are you talking about Ambika Prasad Mishra?
No.
It's the state of UP.
No. Yeah, in regard to 62 matter one. Yes, I'm providing it. One page submission and.
Kyoto Holohon.
No, that is
वो सब
not.
दिखाइए ना वैसे थोड़ी हम मानेंगे.
No, I'll declare. But this is
Go by our thing. You have to tell us.
hold on is different, my lord. This is.
Hold on, the principle
This
is
is.
there.
Hold on, I'll show it. Yellow is not.
No, it will have some bearing. Let us see.
I know about that. But here, I have put a one page my submission and two judgments.
Judgments
Two
you have said.
division, yes,
Judgments you have given.
Yes, two judgments are there. I have given to them also. Exactly on the point, on the sixth shift, the matter is pending in parliament, madam. For amendment of the sixth schedule and for bringing this
They have
anti-defection.
not been able to introduce it in Rajya Sabha. also.
No, it is not there. That also I have annexed it in the report. That your lordship will find it in annexure 2. Matter is pending for the same sixth schedule.
All right, we keep it say on 22nd, 21st of April. Let this matter come up across the way.
Sure.
AG will have to be here. No, actually, let this matter be listed on 21st of April for final decision.
Item 37.
And what is the ground which has been taken, Mr. Das?
Well,
They
the
say that
council,
it doesn't have the council, because the powers are listed.
yes, council doesn't have the power to enact this anti-defection law.
And even in the amendment to the list of powers, list of subjects on which legislation could be
It doesn't
made,
come in.
that does not include
It
this.
does.
That must be the ground.
Yes, sir. These two judgments say the first judgment of the.
Now let the Advocate General also,
Yes, sir.
some new light may have.
Yes, sir. They say, well, under some paragraph they have shown, but that your lordship will recognize. immediately done. That paragraph doesn't give them any.
We'll see.
Those paragraphs have been already
We will conclude it on 21st, hopefully.
deeply organized.
Make please, your lordship.
What is the status of that sports complex, Mr. Pallav?
Before taking up the matter, my lord, the matter relates to construction of the diffuse sports complex of
That's what we were
2004.
asking, no?
My lord, 2017, we wrote to the foreclosure of that we have not received the fund. Then my lord, central government said that it cannot be closed. So the central government asked us to submit a revised estimate, my lord, in 2024, my lord. That revised estimate, my lord, that has not yet been forwarded, my lord. So, my lord, it will be within a month, my lord, revised estimate will be forwarded to the
Have you
government.
put this fact on record?
My lord, we have already filed the affidavit. It is in the, my lord, lordships 179, page 179. Paragraph 12. May I read it? Is 123 of paragraph 5, my lord, we have stated details about the project. my lord.
What? The photographs are self-explanatory. What kind of construction you have done?
There is another affidavit of Director of Sports, my lord. Lordship will kindly see it. They have specified the implementing authority is the Principal Secretary, Tribunal, and they are not doing it, my lord. Paragraph 6 of the respondent 582.
Out of 321.80 plus Chief Minister's Fund, you've been able to do this.
My lord,
What a poor execution of work.
we have stated, my lord,
If it
paragraph,
is audited, all of you will land in trouble.
well, it is a project of 2003 and 4. At that time, my lord, total amount of the project was, my lord.
Quality of work. It
my-
appears that it is in some kind of a remote village where people construct from their own pocket.
It is in a remote area, my lord. In fact, it is a remote area, my lord.
Town.
No, not
town.
town, my lord. It is a, my lord, Lamdadan development block, my lord, Anand development. It is the Dipu Sports Complex, my lord, Dipu, that is stadium, that has been completed, my lord. It is another project. Dipu Stadium project has been completed. The Dipu Stadium project, my lord, that has been completed. It is another project, my lord.
The
Dipu
stand
Sports
of the state of Assam, Mr. Na.
And we have said that it is the Tribunal authority, they have to do. Only the department will issue the utilization certificate. At one point of time, they have sent it, Tribunal authority has sent it. And the
It
utilization,
appears that without your stepping in, nothing will be done. We can't saddle you with that responsibility, but it falls under the overall control of the government.
one block, the HAD department.
Mr. Chutia, Mr. Chutia, tell us one thing.
My lord,
When your re-estimate,
my lord.
have you sent it?
My lord, that instruction, my lord, I don't have, my lord, whether it has been sent or not, my lord. I have just today morning, I have taken the instruction whether revised estimate has been.
Mr.
forwarded or
Burman,
not.
let us have it, Mr. Barua,
Big over.
let us have it concluded. So no use, finding fault with them. It's useless.
No, my lord.
The sports complex looks like a chicken run.
Your lordship will kindly see the inspection report, latest inspection.
We can understand. We can understand that they have just eaten away the money. Now we will take care of that,
Yes.
but let them respond. Let them provide the information whether they have submitted the.
It's a central fund project, my lord. Ministry of Donor has to be informed, my lord.
Donor,
Yeah, that is the thing, my lord. If they are
It's for donor.
central government, my lord, and the fund is required to be released by them, my lord. And it is 2004. My lord.
Pages you have not completed. And that
On the first page, we have completed, my lord.
Second page is
The reason बताता है कि उतना auditorium नहीं था, ये नहीं था, ये था। But the quality of construction is poor.
the lordship,
We are not going to take it from us. We are not going to ask the central government to release fund. We will eat it up that also.
my lord, they can do it from their own fund, my lord. They are a special scheme, my lord. They have stated in their affidavit that they have constructed pavilion.
Except
Only thing,
designating the fund, except designating the transfer and then keeping it in their own pocket.
and I'm my lord, afraid that they want to abandon, my lord. That's why we are here, my lord. For the spirited people.
Mr. Chutia, please file an additional affidavit. Tell us about
Yes,
the details.
My lord.
Mr. J. Chutia, London Standing Council, KAAC, representing response number 6, 7, 11,
12,
And
6,
12.
7, 11, and 12.
66, 7, 11, and 12. Submits that additional affidavit with details of the steps taken by the respondent would be filed by the next day. Re-notify on. We are giving you 4 weeks, file it everything.
In May.
It is so, the progress and the quality of work is so bad that we don't even,
My lord.
I mean, he has flagged it, but then there is no use seeing that there is complete what is the usage, the English uses for this is that seeing this slow of despondence sets in. You have eaten up everything. If this pleases you, it's good now. You have spent 321 lakhs.
But
And
at that
Huh?
time, 2005, my lord.
in 2005,
Madam.
and
20 years.
apart from that, Chief Minister's Fund,
But Chief Minister
and
Fund is
what
for,
is it? You can see, it can be used for, piggery or something.
my lord, 10 crores for each, my lord, area, MSC area has been.
No, I don't think you have done anything to pat your own back. You have not done anything to earn encomiums.
My
It's
lord.
a useless piece of work that
But-
you've done.
Earlier, there was an inquiry from the government also, my lord,
All of them.
regarding the, my lord, contract. Lordship.
Now, we will inquire into it, and if necessary, we will also have it audited. We'll also have inquired whether
Right.
funds have been siphoned off.
My-
And then you face the music, but you must complete it. Give, then we will say.
My lord. Yes, sir.
It's a poor kind of execution.
Right.
No matter whatever you may say, this appears to be a total, you've executed it in most slapdash manner. You've wasted public money. In fact, it is a case of misappropriation, I must say. And if we record it, it will be very bad for you. Let's see, file your additional
Madam,
affidavit.
Madam.
Let us have all the documents and then we'll see what can be done.
Always.
Item 39.
May I
Yes.
please, your lordship? Kindly acknowledge for the day, lordship. My senior is not well. She left the court, lordship.
Who is your senior?
SC, lordship.
Huh?
SC. SC.
Yes, see.
Yes, lordship. Yes. Any date, lordship?
Did you inform him?
Yesterday, I tried to submit the mention slip, lordship, but you object.
Yesterday only you knew that your senior will not be available.
She is not well.
She's not well.
Since yes, before,
All-
day before yesterday, lord.
All right. Yeah, a prayer for adjournment has been sought on the ground of indisposition of MS S seal. S seal.
Seal, lordship.
Learned advocate for the respondent. The learned counsel for the appellant, and learned counsel for the petitioner shall ensure that proper pagination is done by the next day.